Hello, welcome to Human Rights Lesson 5. We are starting our online classes today. And before we start, everybody should have the orange book that has Australian Human Rights Book 2 on it. And to start, we're going to start filling out page 4, which is a bit about you. And I'll give you a few minutes to sort that out. So today we're talking about racial discrimination in Australia, and we're talking a lot about the legal system that addresses racial discrimination in Australia. We'll talk about immigration. Australia is a multicultural society, as you know, and the Racial Discrimination Act and the international conventions from which we get the Racial Discrimination Act. This lesson gives you an example of how UN legislation can be incorporated into Australian law. So Australia is a nation of immigrants. There has been immigration in Australia since 1788. Everybody in Australia is an immigrant. We just came here at different times. The only exception, of course, is Indigenous people. There have been several what they call waves of immigration to Australia. Now, the first wave, I suppose, was convicts, and then we had free settlers, mostly from England and from Anglo countries. However, there were Chinese people and Jewish people on the first fleet. After that, there was a major influx of immigration during the gold rush, where people from all around the world came to Australia. And then after that, there's been successive waves of people coming for various reasons. The White Australia policy, of course, reduced immigration from certain parts of the world. However, after World War II in particular, there was a large amount of immigration because people were unsettled, and there were many refugees after World War II, obviously, and that's where we had a massive wave of immigration to Australia. You find in Australia that we have lots of waves of immigration after wars. So after the Vietnam War, we had many Vietnamese people come here. After the Korean War, Korean people. After the war in the Middle Eastern people, Lebanese people. So there's been waves of immigration relating directly to war. But the main result of this has been that Australia is a country of many cultures, and our official policy is a multicultural policy, which means that Australians are encouraged to maintain their own culture or their background culture alongside Australian culture, such as it is. In a country like the United States, immigrants are encouraged to assimilate, which means they're encouraged to forget their own culture and become Americans. Australia, on the other hand, are a bit more accepting of different cultures, I think. And of course, it's a matter of debate. So, of course, because Australia is a nation of immigrants, racial discrimination has been a constant problem in Australian history. And the United Nations, after the Second World War, looked at racial discrimination in particular, and it came up with the International Convention on the Elimination of All Forms of Racial Discrimination, which is ICERD, or ICERD for short. And this was in 1966, and it was directly related to the UDHR. And Australia incorporated the International Convention on the Elimination of All Forms of Racial Discrimination into the Racial Discrimination Act in 1975. There have also been conventions on the elimination of all forms of discrimination against women by the UN, and Australia incorporated that into law via the Sex Discrimination Act in 1984. And the Convention Against Torture and Other Cruel, Inhumane or Degrading Treatment or Punishment, and we incorporate that into law on the Crimes Act in 1988. Although the Australian government may agree to UN conventions, they don't apply as law until legislation is passed by the Parliament. So you can see between ICERD, the International Convention on the Elimination of All Forms of Racial Discrimination, that was in 1966, and the Racial Discrimination Act wasn't until 1975. That's because of the White Australia policy. the Racial Discrimination Act basically abolished the White Australia policy. So under the Racial Discrimination Act, it is illegal to discriminate on the basis of race. It applies to everybody in the country, and it makes discriminatory legislation before 1975 illegal, and it's a Commonwealth Act, so it overrides state acts as well. But the Commonwealth can pass discriminatory legislation after 1975 depending on the circumstances. So, as I mentioned last week, the Commonwealth Government introduced legislation to make the welfare card legal only for Indigenous communities, which is an example of how they can pass discriminatory legislation despite the Racial Discrimination Act. There was an amendment to the Racial Discrimination Act in 1995, which makes behaviour that offends, insults, humiliates or intimidates on racial grounds illegal. And that's the excuse that's been used to prevent people coming to Australia, people like David Irving, who preach racist doctrines. So if a person is a racist, they can be, or a racist as defined by the Australian government, they can be prevented from coming to Australia under the Racial Hatred Amendment of 1995. So under the Racial Discrimination Act, discrimination is illegal in employment, renting, provision of all goods and services, access to public facilities and trade union membership. These are the specific aspects where discrimination is illegal, but of course discrimination in any other aspect of life on the basis of race is also illegal. So there are two types of discrimination. There's direct and indirect discrimination. Direct discrimination is when a person discriminates against another, specifically according to their race. Okay. Indirect discrimination is when a requirement is put into, say, an employment ad that is not direct discrimination, but is indirect. So, for example, an ad can say, oh, we will only hire people over 180 centimetres tall. And the implication is that many people from Asian countries are shorter than 180 centimetres, so that is an indirect discrimination against people from Asian cultures. The only way that can be made legal is unless the height requirement can be justified. So if there is a specific reason why someone should be tall to do the job, then they can say that. Otherwise, it's illegal. It's indirect discrimination. So the Racial Discrimination Act is a direct descendant of the International Convention on the Elimination of Racial Discrimination of 1966, which in turn is a descendant of the Universal Declaration of Human Rights, Article 1, all human beings born equal. So you can see how the Declaration, which is an aspiration and it's not a legal requirement, becomes an international convention, which is a legal document. And that in turn, the legal document is then taken to Australia. Australia signs the legal document, the ICERD, and then in 1975 produces the Racial Discrimination Act, which implements commitments the country made under ICERD. So that is how UN conventions can be incorporated into national legislation and become law and influence the government of certain countries. So it's just a nice example of that. So basically, I suggest you do the activity on page 17 of the book, which is a scenario about racial discrimination, or maybe not racial discrimination, and see what you think about it and answer the questions. Thank you for listening, and I hope you learnt something from this brief lecture. Have a good week. Bye.